Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. In this episode, we're looking at vicarious liability. This is one of the most practical topics in tort because it answers a very important question. When can an employer be held responsible for the torts committed by an employee? The key point is that vicarious liability is not a tort in itself. Instead, it is a legal principle that makes one person liable for the wrongdoing of another. For SQE purposes, virtually every vicarious liability question can be answered by working through three questions. We'll build the whole topic around these three questions. Let's get started. So firstly, what is vicarious liability? So imagine an employee negligently injures somebody while carrying out their work. The employee has committed the tort, but can the employer also be liable? Well, the answer is often yes, and this is vicarious liability. The employer may have done absolutely nothing wrong. The employer may have taken every reasonable precaution. The employer may have had no personal involvement whatsoever, yet the employer can still be liable because of the employee's actions. And this is known as secondary liability. The employee remains liable, the employer becomes liable as well. The claimant can therefore sue the employee, the employer, or both. And that is an enormously important practical advantage because employers are generally more likely to have insurance and resources available to satisfy a judgment. So what's this three question test I've already alluded to? Well, for every SQE question, ask the following three questions. Question 1, is there a relationship of employment? Question 2, has the employee committed a tort? Question 3, was that tort committed in the course of employment? If the answer to all three questions is yes, vicarious liability is likely to exist. Now let's look at each of those stages, starting with question 1, is there a relationship of employment? Now the first issue is identifying the relationship. Traditionally, vicarious liability applied to employers and employees. Employees work under contracts of employment, independent contractors do not, and this distinction matters. Generally speaking, employers are not vicariously liable for torts committed by independent contractors. A self-employed plumber who causes damage whilst carrying out work is usually responsible for their own wrongdoing. A business that hires that plumber is normally not vicariously liable. So the first thing students need to ask is, am I dealing with an employee or an independent contractor? Now, when we look at employees versus independent contractors, in straightforward cases, the distinction is obvious. Examples of employees include shop assistants, office workers, factory workers, delivery drivers employed directly by a company. Examples of independent contractors include self-employed plumbers, self-employed electricians, self-employed builders. The key idea is business ownership. An employee works for the employer's business. An independent contractor runs their business. Now we're looking at relationships akin to employment, and modern cases have expanded the concept here. So the courts now recognise that some relationships are not traditional employment relationships, but are so close to employment that vicarious liability may still apply. The courts ask questions such as, was the activity being carried out on behalf of the organisation? Did the organisation create the risk? Was the worker integrated into the organisation's activities? Did the organisation exercise some degree of control? For SQE purposes, you do not need to memorise long tests. Simply remember, vicarious liability is no longer limited to traditional employment relationships. The courts will sometimes look at the reality of the relationship rather than the label attached to it. Let's move on to question 2. Has the employee committed a tort? Well, this stage is often overlooked because students jump straight to vicarious liability. But remember, no tort means no vicarious liability. The employer cannot be vicariously liable unless somebody first committed a tort, and that tort might be negligence, trespass, fraud, assault, battery, nuisance, or any other recognised tort. Always identify the underlying tort first, only then should you move to vicarious liability. The third question, was the tort committed in the course of employment? And this is where most exam questions live. The courts have spent years trying to determine whether an employee's wrongdoing happened within the course of employment. The traditional approach recognised two situations. Firstly, authorised wrongful acts. So this is where the employer has authorised the act. This is unusual, but possible. If the act falls within what the employee was employed to do, it is likely to fall within the course of employment. Then we've got unauthorised ways of doing authorised acts, and this second category is much more common. Here the employee is carrying out authorised work by doing it carelessly or improperly. Think of a delivery driver. Driving is authorised, driving negligently is not. However, negligent driving while making deliveries is still an unauthorised way of doing an authorised task. Therefore, it falls within the course of employment, and this is the classic vicarious liability situation. We're now going to look at prohibited acts. So students often assume that if an employer says, do not do that, then liability automatically disappears. But it isn't actually that simple. The real question is, why was the employee doing the prohibited act? So if the employee was still trying to further the employer's business, vicarious liability may still exist. Think about a milk delivery driver who is prohibited from using assistants but employs one anyway to help them make deliveries. The employee is breaking the rules, but they are still carrying out the employer's business, and the court may therefore find vicarious liability. Contrast that with an employee doing something completely unrelated to work for personal reasons. In that situation, the connection with employment becomes much weaker. Now, another common misconception is that intentional wrongdoing automatically falls outside of employment, and again, that is not correct. The key question is whether there is a sufficient connection between the employee's role and the wrongful conduct. A famous example involves employees who abuse position of trust that were given to them by their employer. The wrongdoing may be entirely deliberate, it may even be criminal, yet the employer may still be vicariously liable because the job provided the opportunity and the context for the wrongdoing. For SQE purposes, remember the phrase close connection. That is the modern approach. The court asks whether there is a sufficiently close connection between the employee's job and the tort committed. Now we've got to look at one of the favourite SQE areas, the concept of frolics on their own, the employee who goes off script. Now the question is whether the employee has temporarily stopped carrying out the employer's business and started pursuing their own personal objectives. Imagine a delivery driver who abandons deliveries and drives across town to visit a friend. That starts to look like a frolic. The employee is no longer carrying out the employer's business. Now compare that with the delivery driver who stops briefly for lunch. That still looks very closely connected to work. So the courts, therefore, look at geography. How far has the employee departed from the authorised route? And purpose. What was the employee trying to achieve? Were they still furthering the employer's objectives? And the further the employee moves away from the employer's business, the less likely vicarious liability becomes. So why does the law do this? Well, students sometimes ask whether this is fair. After all, why should an innocent employer pay for damage caused by somebody else? And the courts generally point to several reasons. Employers firstly create the enterprise. They benefit from the employee's work. They create the risk, but most importantly, they usually have insurance available. The law therefore places responsibility on the organisation that created the environment within which the wrongdoing occurred. Employer's indemnity. One final point. If an employer pays compensation, can they recover that money from the employee? In theory, yes. The employer may have a right to seek an indemnity from the employee who committed the tort. In practice, however, such actions are rare, and insurers generally do not pursue them except in unusual circumstances involving serious misconduct. For SQE purposes, though, simply remember that the possibility exists. Bowdie's bottom line. Every vicarious liability problem starts with three questions. Is there a relationship of employment, employee, or relationship akin to employment? Has the worker committed a tort? If there's no tort, there's no vicarious liability. Was the tort committed in the course of employment? Ask, was the employee doing their job? Were they carrying out the employer's business? Is there a close connection between the job and the wrongdoing? If the answer is yes, the employer is likely to be vicariously liable. Now, if you remember nothing else from this topic, remember the core question. Can the claimant make the employer pay for what the employee did, and then simply work through the three-stage test? Now, that's the structure behind almost every SQE vicarious liability question you'll meet. Thanks for watching this episode of Bowdie Shorts.